Good morning, this is Chen, and I'm going to be narrating the Research and Writing 2 video project for myself and Celeste Jimenez. Today I'm going to discuss and explain our scenario as well as different research techniques myself and Ms. Jimenez used to get the information needed for our client. Now, we're going to start with going over our scenario, which is that we have a client who is a surviving child of a mother of 4 children. The mother had, however, before her passing, left her entire estate to her husband, who is not the father of our client. This case is going to be admitted to probate. However, our client would like the will to be set aside. The reason for this is because our client believes that the will was executed and witnessed by 2 different witnesses that were not competent for 2 different reasons. The first witness is named within the will as the executor. This person has the job of ensuring that the last will and testament is carried out to the fullest extent as wished by the deceased. And second, our next witness is the husband of the deceased. The entire estate was left to him, and being a beneficiary of the will could be a cause of concern when being a witness. So we have one person whose job is to fully uphold the will and be unbiased when it comes to the will. And then we have another person who gets something out of the will. So by having them both as witnesses can be cause for concern, especially whenever it's dealing with them being the only 2 witnesses in the case. Because they both have something to gain or lose, depending on the decision made at probate. Now, I'm going to go through a little bit of Westlaw, how you use it, and what we use to find our information. So, first you come into the sign-in page, username and password, sign in. Make sure that you've read the acknowledgement and you're following the terms within the acknowledgement and agreement. Press continue. Alright, so here you have the option to select a client ID. Now, whenever I initially started this search, you could put in the client ID, and I named this one R&W for Research and Writing Video. This basically allows you to go back to your searches that you did while you were looking for this particular client, and it saves you time so that you don't have to reinvent the wheel and restart your research from scratch every time. So continue. So this pop up. Okay. So here we're at the main screen, and because I'm from South Carolina, we chose to go with the jurisdiction from South Carolina. So in order to make sure that you're looking at all relevant information for only South Carolina, we're going to go over here to this box This is the jurisdiction box. You'll click on it and you can select any jurisdiction that you want, but in this case I already have this selected, but we would select South Carolina. Make sure that you don't have anything else selected, as it will change your search results, especially if you're not looking for anything. Another good thing that you might use would be federal, since it does in most cases. In most cases it will be able to be used as binding jurisdiction for state law, just depending on the different topics and whether it has been delegated to the state, federal, or a combination of both. So we are going to save this. Okay, so one of the searches that Celeste did was a plain language search. And when formulating some of these plain language searches, or any search for that matter, you really want to kind of think of what you're searching for. So in this case, we're searching for wills and mainly who can be a witness, what constitutes a competent witness. So you have to think of what is going to get you there. So for this plain language search, Celeste used contested will due to incompetency of witness. So we're looking for pretty much anything that we can use in a court of law. I did spell that incorrectly. Okay, so we're going to try and find what will be able to be used in the court of law. So over here on the left hand side, you can kind of see the breakdown of what everything is so that you can find what you need. So if you're not going to be looking for secondary sources or anything, you can ignore those. If you don't want to look at briefs, you can ignore those. You can really just get to the meat of what you're looking for. So as you can see, we have 4,691 total results, but we do not have time to look through all 4,691. So we're going to choose what we think is going to best get us to where we need to go. So what Celeste did is she went to the statutes, and then she just kind of looked through and found what she thought might be relevant. So here you have like a little preview of everything that's going on, and it pops up with the keywords that you typed in, highlighted, so you can kind of look through and see what may be relevant, what may not be relevant to you. So just looking through, there are several things here, and you can sometimes tell just by the title of what these things are if they're going to be relevant or not. Sometimes you got to look a little deeper. So what Celeste felt was important, or what we could use, was she looked at this number 2 here, which is part of the Code of Laws of South Carolina, annotated. So we go into here and just read a little bit about it. So this was effective January 1st, 2014. So in this case, this is good for us. And the fact that the will was actually executed after that time, so that's fine. And this is the, you can go here and check on the currentness. So this all still looks to be good. Good law. And then basically it explains to you exactly what is required to have the proper execution of a will. So in our case, this is being contested that this is no good. So it basically explains that there are 3 different ways in which a will is executed. So a will can be executed and become self-proving, and if you don't know what self-proving is, it tells you here in this section, which has a hyperlink that you can go to, and it explains everything that makes a will self-proving. And if it is self-proving, then it cannot be challenged, essentially. So as long as it has met the requirements of self-proving, it cannot be challenged. And it's kind of the same thing whenever it's not self-proving but notarized. In both cases, there's someone stating that there is a legality issue as far as pending penalty of perjury if the information in the will and is not accurate, that someone is going to be held liable, and those someones would be the witnesses, as well as the official who executed the will. So it also says in the 3rd section that if something is not notarized and it's not self-proving, then at least one of the witnesses is required to establish proper execution if the witness is within the state, competent, and able to testify. So there you can see that it states that one of the witnesses must be competent. Well, this isn't just enough for us. We have to find out what makes a competent witness. So what I did in order to kind of find this was I went back to our search bar and went to an advanced search. And this brings up the search area for a Boolean search, which is great because it kind of has all the connectors you can use and exactly what that does in order to do your search. But for me, the terms that I used were will and witness, because I want both of those to come up in my search together, and I want them to be in there. And then I also want to have beneficiary or gift. The reason for that is because I want to find someone who is receiving something from the will as well as being a witness. And the importance of doing a search this way is that you really need to know the terms used in your jurisdiction. The reason for that is so that you make sure that you're using the proper terms, because while you might think that you're using the proper terms, if you're not, you might miss some very pertinent information that could be used in your case just because you didn't know the correct terms that's used in your jurisdiction. Okay, so then you see that it puts it in this way, which is the Boolean format that is generated from this box, and then I'm going to search. And I'm also looking for statutes. So you can see that there are more, and I think that there is, at times, this can help you really pinpoint down what you have to look at. In this case, it didn't give me less results like I had wanted, but you could put more qualifiers in your search to narrow the results down. The only thing I will say on this is that if you do put too many qualifiers on what, or search terms in your search bar, it may limit you in so much that you might not find the right information, even though it was out there. You didn't find it because you were too specific. So you want to make sure that you are able to find the information. So you don't want to be so specific that you exclude some valuable information, but you don't want to be so general so that you were to have so many results. Like I said before, I couldn't go through 4,000 some results, and I definitely can't go through 12. But whenever I went through and went to statutes again, I found a piece of the statute that seemed like it properly talked about the matter that I was looking for. So I'm looking for, just looking through, and the first result that came up is the one that I'm actually looking for, and I kind of did the same thing that Celeste did, and I just kind of read through a lot of these previews to kind of get me to where I needed to go. And like you'll see in here, there's a lot of different keywords, key phrases that are in here that kind of up is the one that I'm actually looking for, and I kind of did the same thing that Celeste did, and I just kind of read through a lot of these previews to kind of get me to where I needed to go. And like you'll see in here, there's a lot of different keywords, key phrases that are in here that kind of tell you, like, I'm not going to be dealing with divorce, so I know that that's not it. I may be dealing with family court, but I might not be. What I'm really looking for is things on probate. So like when you see the South Carolina probate code, or even here, or even at the top here. So I opened this first one, and this is a part of the Code of Laws of South Carolina, 1976 annotated, and this is the part on wills, and this describes a witness to a will, and it describes basically that an executor could be a witness, or a husband or wife, any type of spouse could be a witness. However, it says that if they are someone who is there, they have to be a disinterested party involved. There must be two disinterested parties, as well as the husband, or as well as the executor. At least that is the way that I am interpreting this. So I look through here, and I would say that we do not have two uninterested parties that allow us to see this as a properly executed will. Now, I don't know if this was self-authenticating, and I don't know if it was notarized because I didn't have that information. But if it was notarized or self-authenticating, there may be argument that that is a valid will. But in the event that this was neither self-authenticating or notarized, if it was just two witnesses and our deceased in a room signing this paper, there may be cause to say that this is not a valid will. And whenever there is not two witnesses, or two disinterested witnesses to a will in addition to an interested witness, then the devise is null and void to the extent of the value of the excess property, estate, or interest so devised over the value of the property, estate, or interest to which the witness's spouse, or witness issue would be entitled upon the failure to establish the will. So basically this is saying that that particular witness, if they were to be if they were found that this will was no good, or in part no good because they are a witness that is interested, that they can only get the value at which they would get if the deceased had died intestate or without a will, for that part, and then the remaining or excess would be distributed among the other parties that could be able to receive part of the estate if the person were to die intestate. So, for instance, if the spouse only receives 50% of the estate if the person were to die intestate, and then all other parties that are eligible for distribution are able to get equal distribution, then that other 50% would be split among the 4 children equally, if those were the only people entitled to the rest of the estate if the deceased were to die intestate. So I think that this is very important to note, because we don't always find all the information in one spot, and we don't always find it in just statutes or just case law. In this case, we were able to find it in the law under the same code in different sections, which was great. But sometimes you may have to make changes to your searches. As previously stated, you may come up with too many or not enough results to get the information that you need. So in this case, we found law that was still in effect, and it was everything that I needed, really. I think Celeste and I will be able to properly show our supervising attorney that we have the proper information, whether it was notarized or self-authenticating, or whether it was not either of those two things. We can have our attorney have the information to properly advise the client how each of those different circumstances may affect the overall outcome of if the will is set aside totally or in part, or if it was valid completely. So that's all that I have for today. We thank you for your attention and your time. And if you have any questions, please feel free to email us. Thank you and have a nice day.